Everyone, I'm Dr. Kalpana. Today we are going to discuss about a very important topic of corporate law, that is liability of a promoter for pre-incorporation contract. So in this we would be discussing who is a promoter, what are the functions of promoter, and what is the liability of promoter, and what is Indian law when it comes to liability of company for pre-incorporation contract. So we would be examining the intricate legal framework surrounding promoters' liability for pre-incorporation contract and general rule, specific legal provisions, and summary of the various liabilities scenarios. So first, we need to know who is a promoter. So a promoter is a person who conceives the idea of a company, takes necessary steps to form and register that company, and secures capital, business operations to launch it. So a promoter is not an agent, as the company doesn't exist yet, nor trustee in the strict sense, because occupies a fiduciary position, because company has not come into existence, but promoter is already is in the existence. So now come to the legal definition of promoter that has not been defined by Companies Act 2013, but under section 2 subclause 69, a promoter is a person named as promoter in the prospectus of the company. Then definitely he's an important person who has control over the company, because he is taking all the necessary steps to bring a company into existence, on whose directions the board of directors act. So promoter is very important person when it comes to bringing a company into an existence as per section 269 of the act. What are the functions of promoter? So what does he do actually? So he discovers the business opportunities, assembling resources like capital is required, land is required if the nature of business is like that, licenses, compliances, all are done by promoter. Drafting memorandum and articles of association. These are the most two important documents which has to be submitted with the registrar of company when a company has to come into existence. So these are important documents which has to be uh, furnished, supplied to the registrar of company when any promoter goes for registration of a company. Drafting memorandum and article of association, naming the first director, filing incorporation document with the registrar. So these are the functions of the promoter as per Companies Act. Promoter's fiduciary duty: promoter must act in good faith, avoid secret profits, disclose all material facts. If they violate these duties, they may be held personally liable. Now, the most important question is what is the meaning of pre-incorporation contract? As the title is itself indicating, prior to the existence of a company, there are certain contracts which have been signed by the promoter. So these contracts are formed by promoters on behalf of the company prior to its legal incorporation for the purpose of bringing a company into existence. That's why we call it pre-incorporation contracts. So what is the general rule when it comes to liability under these pre-incorporation contracts? The first question is company liable for these contracts? So company cannot ratify pre-incorporation contract because it did not exist at the time of contract was made. So since company was not existing, so how company can take the responsibility of such contracts? We are talking about here a general rule and general principles of contract of law. It had no legal capacity to authorize or ratify any act. There is one important case, Kellner versus Baxter, 1866, established promoters' personal liability. If there is any liability is coming, out of pre-incorporation contract, then it is the personal liability of the promoter. Company would not be held liable. Now coming to what Indian law says about pre-incorporation contract when it comes to holding liability, whether company can be held liable. So Indian law is provided under Specific Relief Act 1963. Section 15 H and 19E, enforcement contracts are enforceable by or against the company if specific conditions are met. Company purpose contract must align with the company's intended objectives and operations as per these sections. If it does meet that requirement, then company can be held liable. Post incorporation acceptance. That's a very important condition to hold company liable for pre-incorporation contract. Company must formally accept the contract after its legal formation. That is called novation of contract or adoption. So novation means there is a new contract. A company is accepting the pre-incorporation contract liability after its existence or incorporation. So acceptance must occur through a novation agreement or a formal adoption resolution. Then only under Specific Relief Act, a company can be held liable for pre-incorporation contract. So Indian law is enabling to enforce the pre-incorporation contract by the company, or it can hold company liable. Now coming to the conclusion, in short, summary of promoter's liability situation: pre-incorporation contract not adopted, promoter would be personally liable if it is not there. Pre-incorporation contract adopted by company, company becomes liable under Specific Relief Act 1963. Fraud or non-disclosure by the promoter, promoter would be personally liable in such cases, not the company. Secret profits made if by the promoter, promoter must disclose or refund the profits which are not allowed under the law. A promoter's role is important in company's formation. So they face personal liability for a pre-incorporation contract unless formally adopted by the company. Their fiduciary duties demand full disclosure, honesty, and avoiding conflicts of interest. So I believe you must be having a fair idea of what is pre-incorporation contract, who is a promoter, what is the liability of promoter, under what circumstances a company can be held liable for pre-incorporation contract, and what is pre-incorporation contract. With this, I would end here. Thank you so much. Happy learning.